Sam identified a number of interesting discussion points in the course of his paper, and in a few moments I might ask the panel to comment on some of those points. But before I do so, does anyone have any questions arising out of Sam's paper that they'd like to raise? No? Okay, well, one of the points Sam raised was whether it's actually necessary to formally tender the T documents. I might ask the panel, perhaps Stephen.
It depends on the member. The rules require the Commissioner to put forward a bundle of documents called T documents, which are the documents, I forget exactly what the test is, it's all the documents that he has in his possession that were relevant to the making of the decision. And usually he puts forward a bundle of them and they're filed. When you get to the hearing, you, as counsel of the Commissioner, your first step is usually simply to tender the T documents. Some members will just say, okay, that's Exhibit 1. Some members will say, you don't need to tender those, Mr. Sharpley, those are already before me. Which is right, I don't know, but that's how it happens. What can happen is that the initial bunch of T documents is incomplete, particularly if counsel goes through the ATO's file and finds more things that should have been in. So sometimes you'll see supplementary T documents. You'll also the Commissioner will sometimes, as part of preparing for the AT, discover completely new documents that he didn't have before. Technically, these aren't T documents because they weren't in consideration at the time of the decision. So the Commissioner should put those in as supplementary bundle of documents, not supplementary T documents. Sometimes they do get stuck in as supplementary T documents. The capacity of a taxpayer to object to T documents is very limited because the rules say they're before the tribunal, but you can object to them on the basis that they're of little or no weight. So, for example, a file note that an ATO officer records of a telephone conversation with the taxpayer's disgruntled ex-wife where the ex-wife says, oh, he told me blah, 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 blah. Now, that'll get in as a T document, but you might say, well, it's rank hearsay, it's of little weight if she's not called as a witness. Where the Commissioner puts in completely new documents that aren't T documents, then as a taxpayer you should be careful because those don't benefit from the automatic in of T documents. And you can object in a stronger way to what are brand new documents, bearing in mind the ATO's, the AAT's usual response to objections to documents is, oh yes, that'll go to wait, Mr. Sharpley, rather than actually ruling them in or out.
Has anyone on the panel had the experience of taxpayers actually trying to force the Commissioner to include additional documents in the T documents?
I've had that experience on a number of occasions, and hence the test for whether a T document should be in or not is etched in my mind. In tax matters, it's whether or not the document is actually necessary, but the power is still in the tribunal to order further documents that may be relevant as well. And whether or not a taxpayer is going to be successful in getting documents in really seems to depend on this question of what the relevance or the necessity of the particular document they're seeking is, and it always seems to come down to the tribunal's hearing being a hearing de novo. So there are plenty of cases saying, well, what the Commissioner thought is actually pretty much irrelevant to the tribunal's case, because a lot of the requests are directed at internal thinking and processes and disclosing the Commissioner's sort of reasoning process to a bit of scrutiny, but for the most part it's just not relevant to the tribunal proceedings at all. There are a couple of exceptions to that, obviously, and that is where there are sort of states of satisfaction or alternatively conclusions. The tribunal is, well, the taxpayer is asking the tribunal to look at the Commissioner's conduct in a way that might actually in some way impugn the decision. But I haven't actually been involved in a situation where it's got to quite that level of scrutiny and the additional documents have actually successfully been put in. But I have had that request made on a number of occasions.
It should be remembered also that there are other ways that the taxpayer can get evidence before the tribunal, including evidence that is in the hands of the Commissioner, and that is by the tribunal effectively subpoenaing or those documents. So there are...
Although there are cases that also say that the summons power shouldn't be used against a party, in particular the commissioner.
You should just ask for an order that they produce it.
Which puts you in a catch-22 to some extent.
Yeah, the equivalent, but the tribunal does have power to seek the further information from the commissioner. So it's not essential that those documents go in via the T documents.
Yeah.
There are other ways to actually get those documents before the tribunal.
Yeah. Or one that people seem to forget is actually just making an FOI request and making sure they've got the document and can get it in some other way.
Yeah.
Yes. I mean, if you do an FOI request and you find a document in the commissioner's file that is helpful for you but isn't in the T documents, then you say, oh, that should be in the T documents.
Yes.
But usually, unfortunately, a lot of people get a lot of attacks in the AAT are wrongly on the process of decision making. Oh, that auditor doesn't like me, that auditor was biased, he had no basis to reach that conclusion. It's all irrelevant, and I have been in the situation of getting requests from taxpayers for production of documents, and you argue against them because they're all irrelevant. They're all about the processes of the tribunal, of the commissioner, which are irrelevant, usually in a de novo hearing.
All right. Does anyone have any questions arising from that discussion? Another issue that Sam raised was just the different approaches that the AAT can take to bringing about a settlement. Julianne, would you like to share your experiences on settlement approaches?
I think Michael's asked me this one because a couple of weeks ago we were in a conciliation in the AAT. Mediations are available in the tribunal, as are conciliations. Normally they'll be before a member. The conciliation will be before a member. Ordinarily it's a member who is not going to be the presiding member in the ultimate case, although if you do look closely you'll see that it's actually such a member is not excluded. And with the permission of the parties could actually hear the final hearing, although I've certainly had absolutely no experience of that and I would think it would be very unusual. The form of a conciliation, which is certainly in my experience most of the alternative dispute resolution that occurs in the tribunal will be a conciliation. It'll be before a member, and this is the general rule when you're in the tribunal is that the tribunal can make the rules, but as Sam said, normally in a proceeding there's a process that is followed. In a conciliation, it's very much a case of the member will make the rules as to how the conciliation runs. And one member will run a conciliation just like a mediation. And the standard way in which a mediation runs, whether it's before, and I've done mediations before a public servant who is a member of the Super Complaints Tribunal, and I've done mediations before a High Court judge. And the basic way that a mediation works is that both probably the same one. Both parties have their spiel at the start, setting out what their position is and why they think that they should win. And then often there is a breakout time when the mediator goes to each party individually. Normally the line from the mediator will be, you're in a difficult position because of X, Y and Z. And then they'll go to the next room and talk to the other people and say you're in a difficult position because of X, Y and Z. And their job basically is to try to bring the parties together and work out some sort of a compromise. And then it becomes a time where sometimes the parties are together and sometimes they're apart. That's the way that a mediation runs, and that's the way often a member will run a conciliation. But I understand, and some other members of the panel may have experience of this, that some members run a conciliation, some tribunal members run a conciliation very much like a hearing. And it's everyone's in the same room for the full time, and submissions are heard, and the conciliator virtually gives a non-binding opinion on each of the points which are being raised, which is another way of encouraging perhaps the parties to settle. And I don't know if anyone wants to talk about their experiences with that kind of a conciliation.
Well, I've had that experience in Adelaide, and I didn't think it worked very well, actually. I didn't think it was a suitable case to take that approach. The member there seemed to be the way he preferred to approach conciliations, although I understand that most of the conciliations in Adelaide are handled by a registrar rather than by the member.
often that approach may, and correct me if I'm wrong, that may be a worthwhile approach possibly for unrepresented litigants, to give them a foreshadowing of what they're in store for before in an actual hearing. But where you're talking to represented litigants who know what's in stake, I'm not convinced that that's the correct approach to take either.
The difficulty, of course, when dealing with unrepresented litigants in a tribunal where there's no costs, being that there really is a minimal disincentive to them going ahead and having a crack at a final hearing and seeing whether the result doesn't end up being different.
Yeah. What's the experience of people in the audience with the conciliation process in the AAT? Do you think it works well?
As you said, different members have different approaches. I've had one where the member just throws open the parties to determine what they want to say, what they want to do. Oh, sorry, thank you. Yeah, so I've had experience in the AAT where the member just opens up and leaves it to the parties to determine the processes. I think somewhere between the two extremes would be the ideal way to run a conciliation. Have some structure and approach is best, I think.
Yeah. Any other experiences people want to share?
Yeah, I agree with what Julianne said. It was like a hearing. Perhaps the only good thing about it was that it got rid of a couple of issues. That was all, but it certainly didn't resolve the matter.
Yeah. Okay. Yeah, I mean, my impression is that the conciliation process has generally been working very successfully in the AAT for the last couple of years. So I think it's been a positive development.
One of the points that was made last week, and I know a lot of the people here today were here last week, so I won't dwell on the point, but the beauty of a mediation or a conciliation for a taxpayer is that as soon as you are in one, you have a decision maker from the ATO in the room with you. That may be the first time that you actually get to talk directly with someone who can settle the dispute from the Commissioner. And that's a big advantage to a conciliation or mediation, and I suspect that's part of the reason why it works.
Okay. I think another point Sam raised was in relation to ADJR and Section 39 capital B review of AAT decisions. Are there ever any circumstances where you might bring an appeal by way of judicial review from an AAT decision? Melanie?
Again, Michael's picking us by reference to matters he's in against us. The circumstance hasn't arisen yet, but we've suddenly got a matter where the question came up as to how it would be that we would appeal once we've got a final decision, and rest assured both sides look like they're going to appeal this matter if it goes against them. Because what we've done in this proceeding is we've actually used the tribunal's process being in its own discretion to have a separate question being determined. So we asked the tribunal to do that. The tribunal's convinced that it could do it. So we've got a separate question that won't resolve the full Part 4C matter that's to be heard. And once we get a decision, how do you appeal that, given that the Section 44 appeal process is only really applicable in respect of final determinative and effective decisions? And the answer seems to be judicial review in respect of the tribunal's decision, and or alternatively seeking a declaration or using the Section 39B of the Judiciary Act route. And that seems to be the answer in respect of pretty much any interlocutory decision of the tribunal. So requests for adjournments, when I was talking about the request for additional Section 37 documents, there are some federal court cases brought under the ADJR Act where the appeal was about a Section 37 T document question. So it's really that seems to be the appeal route for interlocutory decisions. It does raise some interesting questions about exactly how effective that is and how constrained your grounds for appeal actually are, but that seems to be what's available. Although I guess there is also the question about whether or not the parties agree in some way to have the tribunal's decision made final in order to open up the Section 44 route, but that's not something that I've actually had cause yet to attempt to see whether it can be made work.
Does anyone else have any comments about that point? I think a further issue that was raised in Sam's paper was whether, if you've got a taxpayer who's giving evidence about a matter that really only the taxpayer can give evidence about, like their purpose, is it sufficient for that taxpayer to rely on his own oral or her own oral evidence, or do they need that evidence to be corroborated? I might throw that open to the panel. Does anyone have a view on that?
I can't imagine a situation where the Commissioner has brought no T documents and has no basis for issuing an assessment, the assessment appealed from. So what you therefore have is a situation where the Commissioner has filed T documents which the Commissioner says supports his position against a taxpayer who is asserting the opposite with no evidence. It'll come down to the facts, but providing the Commissioner has some basis to form his opinion, I would suspect that the tribunal member may have difficulty accepting blandly with no rebuttal what's in the T documents. If all you have is a taxpayer saying that's wrong, I never did that, I don't know where this is coming from. But it'll be a factual.
Perhaps if I just give you an example. Section 26a, which still in some form exists in the current Act, applied if you purchase property for the purpose of resale at a profit. And there were hundreds of cases through the years before CGT was introduced in which taxpayers argued that they didn't buy the property for the purpose of resale. What about that sort of a case?
Well, I mean, there are provisions that rely on objective purpose. For example, Part 4A determinations, in which what the taxpayer says about his or her intention is irrelevant. But there are some others where subjective purpose counts. But just because someone says their subjective purpose was X, Y, Z, doesn't mean the tribunal doesn't have to believe them. You can certainly say, well, he may have said that, but all these surrounding circumstances make it unlikely, or less likely than not, that was not his subjective purpose, or was his subjective, depending on what you're trying to prove at the time. And I mean, even in cases, there's been some recent AAT cases about this, even in cases, one argument is that, well, let's say, is this deduction for a business purpose is the issue. The taxpayer gets up and says, yes, it was. And there are cases that warn you that the way the scales of justice don't work, that, well, that counts as a featherweight of evidence in favour of the taxpayer unless the Commissioner can rebut it by some positive evidence the taxpayer must win. It's certainly open to the tribunal or the court to say, well, we're not going to accept that pure self-interested assertion without something better. The taxpayer should have documents, or the taxpayer should be able to have some corroboration before we have to accept that featherweight of evidence in favour of the taxpayer. So it's certainly, just because you've got a taxpayer who swears, you know, this is so, that doesn't necessarily mean they win. But if you're on the other side, the more surrounding circumstances you can point to make it unlikely that that is true, the better.
Often I would say the answer to the question would depend on the taxpayer as well. If you've got someone who has a lot of inherent credibility because of their position and they come across as a good witness and truthful and reliable, I think them coming along and saying, yeah, I did it for that reason, actually does have a fair degree of influence, particularly where the Commissioner's case is based on drawing inferences from documents where the alternative inference is also available, and here you've got this lovely upstanding member of the community.
Yes, if there's another explanation which is completely logical, fits in with all of the evidence of the Commissioner, then you're in a good position. But it will always come down to the facts and how your witness presents.
Yes.
And how your witness withstands cross-examination.
Yeah.
On that point.
And it's probably a brave person who goes in and goes, I'm absolutely confident that my witness is going to be fine. So in normal circumstances, I always take the approach of more contemporaneous documents, the better.
A single contemporaneous document is worth 5 hours of self-interested oral testimony. Contemporaneous documents are by far the best evidence.
Do you find that particular tribunal members take more convincing than others in relation to taxpayer evidence that isn't corroborated?
Yes.
So the particular tribunal might make a difference too.
Oh, absolutely.
Okay.
Perhaps that would lead nicely into something else that I think Sam suggested he might throw to us, which was when, I think the expression was the onus shifts to the Commissioner. I don't like that expression.
No. But no offence.
Yeah, no offence. I must admit, I think that there are points in time where the Commissioner is in a position where he has to put on evidence. It's probably heresy to say that, and that's notwithstanding that I don't actually think it's a case of the onus shifting, but certainly in circumstances where the credibility of the witness might be enough to sway the tribunal, if someone is going to come along and say, this is the interpretation, this is what the purpose I had, I actually think that often if the Commissioner wants to challenge that, he has to be able to do that either based on the documents or alternatively based on someone else's factual account. And I have had cases where exactly that has happened. So cases where it wouldn't necessarily have been required by reference to 14 ZZK and the onus of proof, but the Commissioner has actually gone and found the company secretary to explain various documents and explain various decisions that were made by a company in order to effectively rebut some of the taxpayer's own evidence. And I do think that that's important and has to be done in some circumstances.
I mean, it's very rare for the Commissioner to call evidence. But one example is expert evidence, where the taxpayer puts forward a valuer or a technical expert or someone who's going to put forward expert evidence in support of an expert opinion that advances the taxpayer's case. Now, in some cases, you can just snipe or chip at the taxpayer's witness to get the result you want as the Commissioner. So the taxpayer's expert might have used an 8% discount rate, and you can get them to agree under cross-examination that the proper rate should be 6%. But otherwise, you accept everything they say. But in other cases, merely just cross-examining the expert won't get you to the position the Commissioner wants. So the Commissioner will have to call his own valuer or his own expert on US law, for example. Foreign law being a question of fact. So sometimes, most often when the Commissioner calls a witness, it is an expert to confront directly the taxpayer's experts. And questions of foreign law are a classic one, where the taxpayer will call an expert on US law who will say, well, in this situation, this is what US courts would do. And it's very hard to, unless you can cross-examine him on some US authorities that show that he's absolutely wrong, it's very hard to undermine that without calling your own US professor of law to give evidence and no, that's not right. Here's my analysis based on a whole lot of US cases. This is how I believe the US courts would deal with this. But, I mean, that's... I can't remember the last time the Commissioner I was in a case where the Commissioner called a lay witness.
Certainly not in the tribunal, because the Commissioner has the advantage of the T documents.
Yes.
And I'm only aware of the Commissioner bringing lay evidence in the federal court for the purposes of getting documents, audit documents, before the court. And obviously they have to be under cover of an affidavit from an ATO auditor. And the Commissioner doesn't have to do that in the tribunal. And certainly the advantage for the Commissioner of having the T documents is the ability to bring documents before the tribunal without having anybody having to be cross-examined on them or their provenance. And that can be a significant point where the provenance of documents are in question. In the tribunal, the Commissioner, I think, does have an advantage, that the Commissioner doesn't have to prove that provenance in order to get the documents in. That's the only circumstance in which I'm aware of the Commissioner bringing lay evidence.
I mean, even in the federal court, it's rare for people to take a point about provenance of government documents.
But it can happen, and normally they're not the cases where we're all very friendly and just working out a technical point of law. Normally they're the cases where we're not terribly friendly and we're not trusting.
There are provisions in the Evidence Act that let you simply tender government records. So,
well, not just government records, though, the business records, the taxpayer, if the auditors, or of some other organisation.
Yes.
If the commissioners.
But if the commissioner wants to rely on a document that's emanated from a third party in the federal court,
yes, absolutely,
you have to prove its provenance if the taxpayer puts it in issue.
And that's perhaps more for next week's one. But that is another circumstance, come to think of it, which I haven't been involved in, where I am aware of the commissioner bringing lay evidence, and it involves a certain man referred to in the papers from Liechtenstein. But that's the only circumstance, certainly not in the tribunal.
I have had lay witnesses called by the tribunal, called by the commissioner in the tribunal.
What were the circumstances?
It was a Section 13A case, question of whether options lapsed, and the terms of the options required the board of the directors of the company to have made a determination. And there were certain documents that pointed one way, certain documents that pointed another way. And they needed to actually call someone from the company to talk about the determination power and what actually happened around it.
And they were happy to come, or was it subpoenaed? Were they called? Or
I don't think that they were summoned, so they were cooperating.
Maybe they weren't friendly.
Seemed to be reasonably friendly with both sides, but just cooperative and helpful, perhaps.
All right. Does anyone have any final question? No one else? No? Well,
Colin, you've got.
Yeah. Barry.
Just the last one. I was interested in. Thanks, Michael. I was interested in the reference earlier on to FOI applications. Can the panel just comment on the use of FOI applications in tax matters? I've never even thought about doing it.
Lots of people have.
I would always do one prior to the objection decision being reached, because there's some arguments about whether you can FOI the subject matter of a proceeding that's on foot. And I think that in sort of more major tax matters, acting for a taxpayer, it is quite worthwhile to read the commissioner's file effectively. I mean, he'll take advantage of all the exceptions that he can, just to see what he knows and how his thinking has developed over time. So you get memos going backwards and forwards between tax officers. There may be internal panels to whom they've made submissions, the Wickenby panels or Part 4A panels, as a precondition before taking action against the taxpayer. So it can just give you a lot of interesting information as a taxpayer as to exactly what the commissioner already knows and the bases that he's considered and why he has decided to proceed on a particular basis. But most of that evidence, most of those documents would be irrelevant in a Part 4C hearing. But it's really just for the strategic advantage of knowing those things.
The other thing is that you have to pay for an FOI request, and if it's a very, very big matter, then it could end up being very expensive if you actually want to have a look at those documents. And that's something to bear in mind as well. Somebody once said to me, we like always doing FOI requests because it annoys the commissioner and it sucks up resources. I don't think that's a good reason. I think your primary concern is always formulating your case, and that's where you should be putting your resources rather than trying to annoy anybody. But if you think that the commissioner may have materials that will assist you to formulate your case, then that is the one circumstance in which you should do it.
And can I just add, it's quite simple to make the request. There's a form on the ATO website and a dedicated area of the ATO that looks after that.
Yeah, that's why I think the sucks up resources thing is a myth, because the people who do ATO requests are not the people who are doing the objection decision. And I mean, there are some circumstances, not properly Part 4C, but for example, if you were Part 4C challenging the substantive tax, but at the same time doing a Section 39B or some sort of judicial review challenge on a remission decision, then getting all the FOI of all the remission material is worth doing, because that's a circumstance where you're challenging the decision-making process. And I mean, you'll get a statement of reasons, but you'll do better with FOI of all the material before the decision-making.
You'd be surprised by exactly how many times you'll actually find correspondence internally from people saying, I think this person has a reasonably arguable position. And it's kind of like, look,
Yes.
some people agree with us. So it can be quite strategically useful. I'll also make the observation, and I know we've got tax office people in the room, that I've also been involved in matters where the FOI documents that have been produced have ended up resulting in waiver of privilege issues and getting access to a whole lot more material that we wouldn't otherwise have had, just because the FOI person wasn't quite as diligent in redacting the privileged material as perhaps they should have been. So they can be very useful and dangerous for the tax office.
You can also find out, for example, you might have a witness or a taxpayer who's overseas and he's thinking, well, if I come to Australia to give evidence, am I likely to be DPO'd? And that may be a relevant consideration. And I mean, I had a case, and you do FOA and you see an email, you know, strategic DPO of taxpayer is waiting, you know, or something like that. Taxpayer should be DPO'd for strategic reasons, you know, written from one AT officer to another one.
I'll just wrap this up with one final observation. I have also had clients whose set of documents, even though they originated with them, they obtained through FOI from the ATO because they'd lost the documents. So it can be all sorts of reasons for FOI. Look, I'll bring the discussion to an end now. Sam's paper will be distributed to you by email, so I'd commend that to you. Please join with me in thanking Sam for his paper and for the panel and the discussion.